Okay, so we're coming to the last question. And this, I'm going to focus on mediation a little bit more, bring it back to mediation. So my impression is that mediation is a lot more flexible and broad in terms of what you can consider, not like all these rules like and the law and court proceedings. So I'm just wondering if you could tell us in what way is mediation more advantageous when it comes to child support, maybe from your practical experience. Laura, maybe you can jump in a little
Sure, I can jump in. Yes. In mediation, we still have to consider what the child support guidelines are dictating in terms of a child support amount, the table amount, and all the rules that are there. However, families do get to consider a lot more in depth their circumstances, their needs, where they're moving, how they're going to continue to live, how they're going to continue to share certain expenses. So they have a little bit more, for lack of better words, allowance for creativity to develop practical solutions when it comes to child support. And so taking into account all this other special provisions. For example, we've had a family who everybody has to review the child support. And I think, I'm not sure whether we said, I'm sure Eva had mentioned already, but child support, it is the right of the child. So with that in mind, everything unfolds. So the child's needs, financial needs, still have to be met. Mm-hmm. It's not that you can create a regime where the payment of child support is going to become so burdensome that the child is not going to be having the opportunity to what they would have traditionally had, if both incomes would have been taken into account. So, for example, we had a family the other week who created a special provision where the father transferred the equity in the matrimonial home to the mother at a lower rate, so that the children continue to live in the matrimonial home. But now the child support, they created a child support that was a little bit lower because of those conditions. He could no longer now afford, because of the transfer of the equity that was larger than dictated by the legal model. So that's one example in mediation where they came up with a very creative solution where the children's needs were still met in terms of they continued to stay in the matrimonial home. They continued to go to the same school that's, walking distance, things like that. They continued to maximize their time with both parents. However, the child support had to be lowered in that scenario, so they account for dad's contribution in a different way, right? So sort of follow the money. If we follow the money, the children's needs are still met, financial needs, but the child support as prescribed has been shifted a little bit, right? So that's one example of how families can create a different model in mediation.
Just a quick question that came up again. So let's say the couple goes to mediation and they're happy with an agreement. And then say 2 or 3 years down, or whatever, sometime down the road, one parent feels it's not enough and they want to challenge it in court. Would the judge say, oh, when you guys mediated and came up with this agreement, it's not the same as the table amount? Do judges try to switch it back, try to make it revert back to the table amount as much as they can?
That's a good question. So judges know that they have the power to do that, especially if they feel like the child is being cheated in a way, or that the parents' agreement will somehow be insufficient or negatively affect the children. In my practice with Laura, we've never had a family have that happen. And that's because we put safeguards in place, like many other lawyers do, when they have families who are deviating from the child support guidelines. Those safeguards include making sure both parents have very significant and strong legal advice. So they've gone through with a lawyer, they understand what the child support obligations are, and they've said, no, this deviation is appropriate. So having that extra piece is important. Second piece is that we try not to have any agreements regarding the deviation of child support span a long duration of time, because just like when we talked about the marriage contract and the cohabitation agreement, it's very long to anticipate the needs of children far out.
Right.
You just never know what the needs will be.
Right.
So when we have families that make a deal for child support, oftentimes those deals or arrangements are only a year or two, and not much more than that. Because we flag for them, they always have to be exchanging financial disclosure. They should always review the child support. And it does have to be context driven, right? To avoid it being set aside in court. So putting those things in place, making sure there's a lawyer involved, proper financial disclosure, and a very short duration of when the child support is changed avoids a judge stepping in, typically.
So interesting. So even in this situation where the couples are amicable, like they're willing to work together, of course, there's still this continuing obligation, periodic financial disclosure down the road, right?
Yes.
Like, so because things change, all the time. So every year that the couple?
It's every year.
Every year they review.
So every year, whenever families receive their notices of assessment, they're supposed to exchange those notices of assessment and recalculate the child support. They may, to build on what Eva was mentioning, they may continue with their arrangements, such as a creative child support that they came up with. So they may say, okay, that's fine. We're reviewing it this year. However, we're okay with the agreement we've made last year. So that continues until the next review and the following. But it should be done transparently. The review still has to happen, and it should be done in writing. So if they are going to continue a creative way where they say, okay, child support is 500, but we agree at 400, then they should still exchange the notices of assessment, have something in writing acknowledging that they have done that each year and that they either have continued with the 400 or now they're moving to the 500 child support amount. So that protects everybody, protects the payor, protects the recipient. And if there is a review or an audit later down the road by someone, then they will find some form of a trace that there was transparency, discussion, and financial disclosure was done appropriately. So I think that's the most important thing. As long as parents enter agreements eyes wide open and financial needs of the children are met, those would be they will be honored. The problem is when there are what Eva has mentioned earlier, where there are nefarious intentions, when people are trying to get out of paying child support, ultimately, end up hurting themselves rather than the child.